SJC-13873, Commonwealth versus Byron Palmer.
Okay, Attorney Collins.
Good morning, Madam Chief Justice, Your Honors, and may it please the Court. My name is Craig Collins, and I represent the appellant Byron Palmer. When the police seized Byron Palmer, they were investigating a crime that had occurred 12 days earlier. The suspect in that crime wore a mask, and the suspect's face was not visible on the video that the police had. The police acted based on one officer's hypothesis of what this suspect would have looked like without a mask. And even this hypothesis yielded only the most minimal description of skin color, hairstyle, and a hat that would not have meaningfully distinguished Mr. Palmer from any other young black man in the city of Boston. It was a description that could have fit any number of young men in that community, Your Honor. And I might add that even the part about the hairstyle, as Your Honors will see, looking at the exhibits that are both in the appendix that I've submitted to the court, the hairstyle was not even visible at the time of the arrest because Mr. Palmer is wearing a hat, and there was never any point in the photo, either the photograph or the video that I've looked at, where you can see the hairstyle on the day of the arrest, Your Honor. And the hairstyle was a very common hairstyle, a dreadlocks hairstyle, which this court has addressed in Commonwealth v. Davis as being not a particularly meaningful descriptor, Your Honors. Now, one of the most striking features of this case—
Before you go on to the description of the defendant, when do you suggest, I know you have it in your brief, but now that we're all here together, when do you suggest is the constitutional point of seizure?
I have two alternative arguments on that, Your Honor. At the very latest, as even the appeals court majority found, Your Honor, Mr. Palmer was seized when the police began chasing him. So at the very latest, he is seized at that point under Commonwealth v. Stout and even under Commonwealth v. Thibault years before Stout, Your Honor. Now, as I argue in my brief, I also believe that he was seized even before that, when a total of 7 officers approached him. 3 detectives approaching from one direction and walking abreast of each other with the badges displayed on the outer garment, Your Honor, and 4 uniformed officers approaching from another direction.
Is the record unclear about whether he could see the 4 uniforms?
Well, no, I submit that it's not unclear, Your Honor, because on Officer Rose's testimony in Volume 3—
I agree with you. I think at least on this, I think that Justice Hirschfeld was correct as far as your first premise, but I'm not so sure about in dating it a little bit earlier. So tell me the testimony about the 4 police officers.
Yes, Officer Rosa, whom Judge Dolan credited, Your Honor, testified, and this is on Volume 3, page 65 of the suppression hearing record, Your Honor. He talks about Mr. Palmer running past Officer Rosa, and then Officer Rosa runs after him. So if Palmer is running past Officer Rosa, he obviously sees him, Your Honor. And then Officer Rosa, along with all the other uniformed officers, give chase, and they actually give chase pursuant to a signal by the lead uniformed officer, and this is on page 3, Volume 3, page 70 of the transcript.
It's a rather short chase, correct?
It's a short chase, Your Honor, but I think it's very clear that he sees
right across the parking lot. It didn't strike me as all that...
Yes, it's across the parking lot, Your Honor. And as you'll see in Officer Rose's testimony, which I believe is on Volume 3, 65, he talks about turning slightly, that Mr. Palmer catches his eye as he's running. So Palmer is obviously seeing him, and Officer Rosa says that he turns and runs to get him. So it is a short chase, but Palmer definitely sees the officer, and it's very clear from Officer Rosa's testimony that the detectives are running after Mr. Palmer as well, and there is a police wagon.
Does it really matter? Because it seemed to me that the salient issue on the moment of seizure is whether or not it encompasses him ditching the drugs, right?
Oh, well, yes, Your Honor.
And on both of your propositions, those two events happen before that, right?
Yes, Your
It's
Honor.
only if you get to the moment of seizure or the Ditkoff position that it becomes relevant, correct?
Yes, Your Honor. And what I would point out, Your Honor, I think one of the significant features of that aspect of the argument, Your Honor, is that the Commonwealth's argument about Mr. Palmer supposedly throwing the drugs down before the chase and before the seizure, that is never part of Judge Doolin's findings. That language is nowhere in Judge Doolin's findings. Judge Doolin never once wrote that Palmer definitely threw the drugs down and the police then began chasing him. If Judge Doolin had found that, he could have based the entire reasonable suspicion finding on that without any consideration of the robbery issue, Your Honor. But instead, Judge Doolin based everything on the robbery, the analysis of the robbery, and he leaned quite heavily into flight as a factor in the reasonable suspicion calculus, and I submit that he did that in a way that directly contravenes the holding of Commonwealth v. Warren, Your Honor, that flight is to be given little to no weight in the reasonable suspicion calculus in situations where the person is otherwise free to walk away from the police. And going back, I'm sorry.
I was just going to say, does the video help determine whether this was the person who they had reasonable suspicion?
No, Your Honor. I submit, Your Honor, that as Judge Massing said in his dissent in the appeals court, the video was quite helpful to the defense because the video does not show any particular resemblance to the person on January 2nd, Your Honor. And I would note that this is
Clothing.
I'm sorry, Your Honor.
What about the clothing? The
The clothing, there was almost no resemblance. The only alleged resemblance was the hat. He was not wearing the same jacket, and he was not wearing the same sneakers, Your Honor, and that's undisputed in the record. That's on page 170. He was not wearing the same shoes, and on page 169 it states that he was not wearing the same jacket as the suspect. The only alleged clothing similarity was the hat, Your Honor, and that is 12 days after the alleged offense, Your Honor, the actual offense, but 12 days after, Your Honor. And again, this case is, the investigation is conducted in such an indirect and attenuated way. You know, amici have aptly likened it to a game of telephone, Your Honor. This Officer O'Donnell, who viewed the video on January 2nd, she then views another video on
Sorry,
Let's stop there. O'Donnell views the video on January 2nd, as does Ang.
Yes, after O'Donnell showed
And then the video from January 3rd, again, is viewed by O'Donnell and Ang.
Yes.
Right? So the only thing that Ang is relying on from O'Donnell is the "your guy is back" screenshot.
Yes, she's
Right.
relying.
So everything else is in the mind of Ang already, and Ang now gets from O'Donnell a photograph or screenshot, I guess, of the suspect, who turns out to be your client. And Ang has now herself seen twice a video showing the suspect.
But a couple of very important points about that, Your Honor. It's undisputed that Ng did not make any visual identification of Mr. Palmer's face on January 14th, and that's in transcript volume 1, page 52, and Judge Massing also refers to the issue in his dissent, Your Honor. So she's not making any identification based on her looking at the face of a person in the video and then seeing the person and saying, oh, this is definitely the same man.
And also, I guess just because you're more familiar with the record than I am at this point, is there nothing about other aspects of his character that Ang could rely on or did rely on?
Well, as I say, the way she...
How he walks.
Yeah, the way...
How, his gait, his size, his, other aspects.
As to gait, there was nothing, Your Honor. As to size, as Judge Massing put it in the dissent, she makes a brief reference to size, but with no details about height, weight, build, anything. It was just a very brief passing reference. She references hairstyle. Again, as I say, the videos are going to show, and the picture, The hairstyle isn't even visible.
Would you concede that the hat is distinctive?
I don't think it's terribly distinctive, Your Honor, no, because a couple of things about the hat, Your Honor.
What backstraps this whole discussion is we're not talking about probable cause or beyond a reasonable doubt. This is reasonable suspicion.
Yes.
Here we have the houndstooth, the checkered patterned hat, clearly visible in the robbery video, the Brooklyn Nets, right? And that's the same hat he's wearing when he's arrested.
A couple of points on that, Your Honor. First, the Brooklyn Nets, there's actually no testimony from the witnesses on that as I was looking at the transcript. The
We've got a video that's as clear as day. We don't have to.
The prosecutor says it, but again, this is 12 days after the crime, Your Honor. And under Commonwealth v. Cheek, it's the Commonwealth's burden.
I don't know if the Brooklyn Nets is a down goose jacket.
I'm sorry, what?
Down goose jacket.
Down goose jacket, yeah. It's the Commonwealth's burden to present evidence as to exactly how uncommon such a thing is, and there was nothing presented on that score, Your Honor. And as a matter of common sense, Your Honor, Boston and New York are two cities on the eastern seaboard, roughly 4 hours apart by car, Your Honor.
Is there anything to the fact that the hat was being worn by a person in that same complex?
Well, again, Your Honor, there's evidence in the record that there are 10 buildings in that complex. It's a very large complex, and it's 12 days after the fact, Your Honor. So we're not talking about 20 minutes, 5 minutes after the crime, 30 minutes, not even talking about the next day. We're talking about 12 days after, Your Honor. And as I put in my brief, I don't think it's realistic to say that we would ever sustain, a search of somebody walking around Tremont Street, Boston Common, simply because they're wearing the same type of sports hat from 12 days ago. I mean, it's one thing to 5 minutes ago, but 12 days is quite a difference, Your Honor.
It's different when there's a call to stop someone based on a description versus a police officer or someone else watching a video to make a conclusion.
Well, I
don't know if we have any cases on that, right? But
well, I would submit that you do have cases on that, Your Honor, in terms of the line of cases involving Commonwealth v. Ples, Commonwealth v. Wadsworth, and Commonwealth v. Pena. I think the law is very clear.
Involving sufficiency of evidence or beyond a reasonable doubt. This is reasonable suspicion.
Well, that's true, Your Honor, but I think it's also very clear under those cases that when the police are looking at videos and that sort of thing and trying to reach a conclusion about who was in the video, that is a matter of opinion. That's stated under Commonwealth v. Pena and the other cases, Your Honor. And it's not the same thing as an eyewitness identification. It cannot be treated the same way. At trial, it wouldn't even be admissible in absent extraordinary circumstances that aren't present here. For a reasonable suspicion analysis, certainly it could be considered, but it's definitely not the same thing as the victim saying, oh, this is the man. In this case, as the court undoubtedly knows from the record, the victim never made any identification, even pre-trial. The victim never once picked Mr. Palmer out of a photo array or anything like that, and Mr. Palmer was acquitted of all the robbery charges at the trial, Your Honor. But I would submit that for the purposes of a reasonable suspicion analysis, certainly it's one thing for the court to say that the police suspected that Mr. Palmer was the same man. Or first of all, that they suspected that this person on January 3rd was the same person as the suspect on January 2nd, and that they suspect that Mr. Palmer resembles the man on January 3rd. But to say that it was a certainty and that the January 3rd man was definitely the same man as January 2nd, I don't think
that's not the standard, but that's also not what, I mean, Judge Doolin credited Detective Eng's testimony.
He did, Your Honor.
And Detective Eng said, I thought that's the same guy who was the suspect in the robbery.
But again, Detective Eng is viewing a robbery suspect who's wearing a mask. The face is not visible.
Yeah, but whether or not you disagree with the fact that Detective Eng thought that was the person and Judge Doolin credited that, that's the framework that we're in.
But again, Your Honor, Detective Eng is relying on this text from
No, and what made you think that? This is page 52, I think, of volume 1. Answer, my observation was that the person who we're speaking to in the parking lot, when I visually saw him, I believe that to be the person responsible for the robbery. And what made you think that? Based on the size of the suspect, the same complexion, he was wearing the hat that he was wearing, And she goes on to say some other things. But Detective Ang says, based on my observations of these videos and being there that day, that's who I thought it was.
And if you look a little earlier, I think on the same page or a few pages before,
Yep.
it's clear that Yang is basing this on receiving this text from Officer O'Donnell saying, your guy is back, and that's on Exhibit 5, Your Honor. If you look at Exhibit 5, Mr. Palmer's face isn't even visible in that photo. The person has the face turned away from the camera. The face is invisible. It's on page 152. It's clear that she's not making a visual identification of his face. She's basing things on skin color, a hairstyle that cannot be seen because of the hat, and the hat.
Again, you're more familiar with the record. Was O'Donnell watching the live feed? So she's watching.
She was not, at the time of the robbery, it's my understanding.
Not at the time of the robbery, at the time 12 days later, when O'Donnell sends the screenshot to Ang and says, your guy is back. She's not just got the screenshot, right? She's got a whole photo, sort of real time watching a TV show, basically.
There's evidence in the record that it was O'Donnell's job to watch the live feed. As to what she was doing at each specific minute, as to whether she was watching it continuously that day on January 14th, I don't think there's any evidence in the record about that. But there is evidence in the record that she sends this text, a screenshot, saying, your guy is back. And, the screenshot is really rather ridiculous in that it's saying your guy is back and you can't see the face of your guy, Your Honor. So it is, in that perspective.
The testimony yet, but does Ang describe how close he is? Does Ang describe how close he is or how long he has to look at your client?
How long Ang had to look at him?
Yeah, I understand O'Donnell is watching a screen and she's saying your guy has showed up. I'm just trying to understand. Justice George read you the transcript. He looks at the complexion, the hat, and the size. But I'm just trying to understand how far away is he or how close is he to, and how long does he have to observe him? Is that in the testimony?
I don't think the time is broken down with very great precision in the record, but from the way the testimony came in, it sounds as if this was all rather quick, that the detectives approached, and Detective Andros called out to him, and then that Mr. Palmer, and it's important to note, not only Mr. Palmer flees, but the other two men who were with him also flee because of this phalanx of 7 police officers approaching in different directions, and a police wagon that is a prisoner transport vehicle, obviously, is right there as well. All the individuals flee at that point. And I might add that Detective Andros, later at trial, mentions that he's chasing Palmer before anything is allegedly discarded from his pocket, Your Honor. And again, so this is the detectives chasing him 12 days later, Your Honor, and I would respectfully submit that under Warren, this is the classic situation in which a person is otherwise free to leave and not respond to the police inquiry, because this is not the police responding 5 minutes after a crime or even 20 minutes. This is the police coming in 12 days later based on an analysis of video and an officer speculating that this person looks like, but may look like what the suspect would have looked like without a mask, and may look like this person on January 3rd, who we think is the suspect without a mask. It's the classic example of a situation in which a citizen under Commonwealth v. Barros.
What's unreasonable about that?
Sorry, what?
What's unreasonable about that?
What's unreasonable?
Well, hold on a minute. So O'Donnell says to Ang, your guy's back.
Yeah.
And that informs what Detective Ang does.
Yes.
She testifies that based on that, I go to the scene.
Yeah.
But then she testifies during her direct examination at the motion hearing, here were my observations. Here are my observations. Not what O'Donnell's telling me. Here are my observations, which we know from the record is based on her independent review of January 2, and I think in the next day. She saw them as well. So what's unreasonable about her suspicion that based on the 2 videos I'd seen before and me being proximate, and we saw the body cam, they're not far away from one another, and the chase was, I wouldn't even call it a chase. It was that quick. So you could tell from where they were that they're close enough that she can't rely on her observations and say, I think that that's him. And that's not reasonable?
couple-
Why isn't that reasonable?
A couple of points. I think it's not reasonable because she's not identifying the face. He's not wearing the same jacket. He's not wearing the same sneakers. There's tremendous differences in clothing.
That's all great cross-examination stuff, but there are still other things that she's identified in her testimony
Right.
as to why I thought it was the same person.
And I would point out that she's by her own admission, not making a visual facial identification. She's relying on a text by Officer Ng.
To alert her to the scene.
So what?
To alert her to the scene.
To alert her to the scene.
Yes.
And
But not, according to the testimony, to identify your client as the person that Ang saw on the second and the third.
yeah, but the thing, it's very clear that O'Donnell is the one making the supposed identification. Ng is following up on that and following O'Donnell's lead. And under cases such as Commonwealth v. Keene, an officer can rely on a police flyer from another department, another officer, but the Commonwealth has to bring in the evidence about that police flyer and why it was reasonable. Officer O'Donnell is the one saying, oh yeah, this is the guy, your guy is back, and the Commonwealth never calls Officer O'Donnell as a witness. So it's a remarkably...
Where in the transcript can you point us to that she said, I relied on Officer O'Donnell in making the determination that that guy on the 14th?
I believe there's language about reliance right on page 147. I think, as with my memory, I believe that's one of the pages where she mentions that, and I think also 152, Your Honor. Definitely, though.
Volume 1?
Volume 1, Your Honor. I think it's very clear under her testimony that she was indeed relying very heavily. She had to because she was not making a visual identification, and it's also clear under her testimony that she testified that they were going over there to do a threshold inquiry. She was not saying that, oh, I definitely recognize him and we were going over to place him under arrest. That was the opposite of her testimony. She's saying that they're simply going over to do a threshold inquiry or try to get him to talk, and then he runs, and then it's a classic Commonwealth v. Stout, Commonwealth v. Thibault situation that the police are not allowed to chase unless they have reasonable suspicion at that point, and I submit that they do not.
May I ask a question, Chief?
So,
I have a quick question for you. Was there any evidence in the motion to suppress hearing regarding the location? In other words, how far from the site of the original crime was the site of the subsequent encounter with the defendant?
it's in the same development, but my memory, I believe that this parking lot, I believe, is at 265 Center Street, and the crime, I think, is like the next set of buildings over, I think at 279, if I'm not mistaken. I would have to ask the court to take a look, double check me on that, but I think
guess
that's
it
what
would
your
be,
statement is.
I guess it was self-evident that it's within the same housing development because it's all subject to the same surveillance.
I'm sorry, I couldn't quite hear the last part.
It's all within the same housing development.
It's within the same housing development, Your Honor, but if my memory is correct, I don't think it's the exact same building that they're at. I think it's like the next building over, Your Honor. And as I mentioned, there is evidence in the record that it's a large development with 10 buildings, so clearly hundreds, probably thousands of people either living in the development or in the neighborhood, and with a very general description of hairstyle, allegedly, which I don't think they could even see, skin color and hair. Yeah.
You're over.
Yes, I see that, Your Honor. Thank you very much for the court's indulgence, Your Honor. Thank you.
Attorney McLean.
Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. Justice Wolahojian, I would point you to, in response to your question about where the Officer Ng responded to, I'd point you to Motion Transcript Volume 1 at page 47.
Okay.
They responded to 275 to 277 Center Street, so the parking lot sort of area between those two buildings. And the crime here occurred in that same exact area, 275 Center Street. Here, the initial question has to be answered is when the stop in the constitutional sense occurred. And the answer to that question is that the defendant was not stopped by the initial approach by the three detectives, nor was he stopped by the initiation of the very, very short pursuit after he took flight. He was in fact stopped when the officers placed their hands on him at the conclusion of that very brief pursuit. Justice Gaziano, as you referred to it, the Ditkoff position. That's when he was stopped.
It's more the Hodari D position.
Yes, sir. Yes, sir, it is. Yes, sir, it is.
So why?
So we'll start with the initial approach. Why was the initial approach not a seizure? There are two things you could point to justify it was a seizure: the comment that was made by the detective as they approached, and then the surrounding circumstances. So here, the initial comment was just a request to engage in a conversation. It was calm in tone. Motion transcript volume 1.
So you don't think it was coercive?
No, Your Honor. No, Your Honor. And there are a whole series of cases. I point you to Lopez, Martin, Mata, where you can approach a person as a voluntary encounter and ask to engage them in a casual conversation. That's what happened here. No demand, no command. So the comment from the detective did not constitute a stop in the Constitution.
Do you have any cases where there's 7 police officers or 3, let's just say 3+ police officers, where it's other than coercive?
Well,
The hey, how are you? Let me talk to you cases.
so Mendenhall was 3. DePisa was officers got out and blocked on both sides. Michigan versus Chestnut was 4. Pimentel was 3. Pagan was 3. But those are the officers that are together approaching them. Here, there was 3 detectives that approached the individual. There were 4 uniformed officers a little ways away. There's no factual finding from Judge Doolin that the defendant was aware or even
So
noticed.
you think the 3 detectives weren't together?
No, the 3 detectives were together, and there are a series of cases that say 3 officers approaching doesn't constitute a stop in the constitutional sense. And there's no factual finding that the defendant was aware of the 4 uniformed officers. Yes, they were present, and there was testimony credited that they were between 10 and 20 feet away.
Maybe I lost it, but where did Judge Doolin find? When did Judge Doolin find a stop?
Basically, the Hadari D position, Your Honor. So here, the defense counsel also just acknowledged that during that initial approach, that after the initial approach, when the defendant began to take flight, he took flight past the uniformed officers. So there's no factual finding there at all that he was aware of the uniformed officers before he took that flight. So I don't think this is a situation where the surrounding circumstances became coercive based on the number of officers present. So you can't place the stop in the constitutional sense at the initial approach. So where's the next inflection
So
point?
now we got 7 officers chasing him.
After he begins fleeing.
Yeah.
So
So let's move forward to that.
okay, so that's the next inflection point, is he sees the detective, takes flight, and then the group of officers begin to pursue him. So does that pursuit constitute a stop in the constitutional sense? And no, it doesn't. And I'd point you to Franklin, Shane S., Powell, Franklin and Powell, both from this court, Shane S. from the appeals court, all of those cases indicating that mere pursuit by officers does not constitute a stop. It takes pursuit plus. So here, there's no additional assertion of authority. There's no verbal command. There's no blocking his path. None of that happens at the initiation of what we're calling the pursuit.
Why isn't the sheer number of officers involved put into that calculus as well?
Well, there's no factual finding from Judge Doolin that he was aware that he was being pursued. No factual finding to that effect at all. He sees a detective, he turns and runs. No knowledge at all that he's actually being pursued by these people, so they're not
You
restricted.
don't think he can hear them behind him?
There's no factual finding to that effect at all.
But is there any factual finding that he didn't hear them?
No, but that would, Your Honor, that would be adding factual findings that are contrary to the judge's.
And when we look at the body cam footage, how long is how long does this last, this chase?
Seconds. It's
Right.
very,
So
very,
it's really across 50 feet in a parking lot, right?
yes, Your Honor. Yes,
So they were close. Okay.
he makes the observation of the detective tries to gain his attention. He makes the observation. He turns and runs and
They
begins
get him really quick.
pitching things. It's just a few seconds until they then actually put hands on and apprehend him. And that's the moment when his freedom of movement is restrained. That's the moment of the constitutional seizure. So is that a valid seizure? You add up all of the things that you have until that point, which includes the flight. Now,
Sorry, can we just go back a second? The judge's decision doesn't include a specific factual on this finding on this point, but the judge did say that he credited the testimony of the BPD officers who testified, correct?
yes,
And one of the officers, I think it's Rosa, but I could be wrong. Doesn't one of the officers say that the officer actually made eye contact with the defendant as he's running?
after he began running, yes,
And isn't that officer one of the uniformed officers?
yes.
So there is actually credited testimony that the defendant saw the uniformed officers running at him.
Saw the uniformed officer. The officer did not testify that I was running at him when he saw me. As
You don't think that's self-evident from the video? They come, yeah.
No, I do not. If I turn around and run away from you, I have no idea if you're pursuing me or not. And that's basically what happened here. The defendant could have testified at the motion to suppress hearing and said, I was aware that 7 officers were engaged in a pursuit of me in a parking lot. He did not. And there is no factual finding that he was aware. But even if you wanted to infer one, which I don't think is appropriate, but even if you wanted to infer such a factual finding, that still means that the flight counts in the reasonable suspicion calculus, because the flight had begun before he became aware he was being.
The only thing that matters is when he emptied his pockets. Reasonable suspicion, right?
Well, it could. That's an entirely separate basis of reasonable suspicion, whether he's abandoning narcotics, basically controlled substances. From our perspective, he's not stopped until the end of the brief flight, so we get all those observations as well. So now we have 2 suspected crimes, both the armed robbery as well as at least possession of or distribution of controlled substance. So it all depends on when you precisely place the stop in the constitutional sense. And here, because there's no factual finding that he was aware he was being pursued by these officers, there's no basis on which to say the pursuit could have constituted a stop in the constitutional sense. So he's not stopped until they
If he
actually.
was aware that he was being chased by officers, would that have been enough, in your view?
It could have been. It could have been. And if it was enough, so I would say no, it's not. Even there, it's not. But I would point you back to Franklin, Shane S., and Powell, all saying that pursuit alone is not enough. It has to be
About Matta?
Excuse me?
What about Matta?
Well, so Matta had 2 components to it, if my recollection is correct. There was an initial officer's attempt to gain communication with the 2 suspects. They walked away from him, and that was not a stop. Then there was a subsequent attempt by a different officer, and that was a command to them. Like, I forget the exact wording, but it was stop, come here, something to that effect. They turned around and ran. That was a stop because of the command that was issued, not because of the pursuit once they were running. That's what Matta actually turns on, is the verbal communication. And here there's no such verbal communication. There's also no attempt to block the path, box him in, nothing to that effect. None of those things that would make a pursuit be an actual stop.
So you're saying that when 7 police officers converge on someone and run after them, there's no coercion and that someone's free to leave?
Well, what I'm saying, Your Honor, is at a minimum, you'd have to have a factual finding that the person was aware that 7 officers had, in your terminology, converged on him.
Why can't you infer that from the numbers of people involved?
In the short constrained area in a little courtyard, in the testimony that Justice Dewey just read to you, which was credited.
Isn't there also a paddy wagon too? Is there
Yeah.
We don't use paddy wagon.
whatever the word is?
Prisoner transport.
Is there a prisoner transport vehicle or whatever it is?
There was a vehicle in the general area. I don't recall any specific testimony about
Doesn't
how it.
that add to it too? Doesn't that add to the element that
If the defendant was aware of it.
Exactly. It could, as one of the factors in the totality, if the defendant was aware of it. And here there's no factual finding he was aware of it, and he did not take the stand and testify to that effect, which he could have. So ultimately, yes.
So you're also, just sorry to interrupt, but your position also is that because the motion judge didn't find that he was stopped or didn't make a finding as to whether the defendant was aware of the 7 officers chasing him, and because the motion judge decided that the stop happened once hands were placed on him, we can't infer that because it would be counter to the factual findings of the judge?
Correct, Your Honor.
So what's the meaning of his flight then? Why? So I'm just trying to understand the Commonwealth's position. 7 officers arrive, converge on the defendant flees, but we are to assume that one does not follow from the other. No inference can be drawn about his awareness of whether the officers were there.
He was surely aware that the detective wanted to speak with him. And the detective was with 2 other detectives. So you have 3 BPD members, detectives, approaching him. That much is clear. The other uniformed officers to the side, 10 to 20 feet away there's no factual finding.
Right, so if he's aware of that and he takes off, then why would we then say he's not aware that they take off after him?
Because
Why don't these inferences all just flow one from the other? Why would his knowledge end?
Well, I can only be aware of what I can see or hear or smell. If I turn my head away from you, I can't see you anymore. I don't know what you're doing.
Not necessarily, and it's not to split a point, but we have, and you've tried cases when we talk about and instruct on reasonable inferences. So if you see this number of police officers and you know that the three that approached you were coming to talk to you when you turn and you run, it's not reasonable to infer that the defendant then thought they're running after me. It's not like you thought that they were all going to just stand there and continue their day.
Well, Your Honor, I don't think that's a factual finding that the court can make because it's contrary to the ultimate conclusion of law that the motion judge reached here. In a different world, under a different set of facts, with a different conclusion from the judge.
I'm sorry, what's the conclusion that this would be counterfactual to?
The point of the stop?
Correct, Your Honor. Correct, Your Honor.
Well, that doesn't mean he didn't know that they were chasing him.
But there has to be an affirmative factual finding to that effect, and there is no affirmative factual finding to that effect.
There could, okay.
Even if I accepted that, oh, sorry, Your Honor.
There's only 3 minutes left, and I think you should probably move to the reasonable suspicion portion of this, just because.
Yes, Your Honor. Tricky to do because we haven't identified exactly where the stop is, but I'll start with.
It's where Hirschfang concluded it was.
Yes.
All right, so if the stop was at the initial approach, is that what?
No, not the initial
start
approach,
running.
after the chase.
Okay, after
After the drugs were thrown.
Okay, so if the stop doesn't occur until after the drugs have been abandoned, after he began running, then what we have is the description of the defendant.
I'm sorry, before the drugs were thrown. Before the drugs were thrown, he's running, Sumi's seized, and then throws the drugs.
Right, so that means we have flight as a part, the running is a part of the analysis here. So flight factors into it. So what we have is, we have the description that Detective Eng testified about, as Justice George pointed out clearly on transcript volume 1, page 52, where she noted size, gender, complexion, hairstyle, and the distinctive item of clothing. So we have that as a description.
Can I focus on the hat? Because size and complexion is not going to get us very far, is it? And I mean, his size, he's like 5'10". I can't remember what he is. There's nothing distinctive about his body shape or anything else. He's what size?
6'1".
6'1", of dark complexion. Like I can't remember, light complexion, dark complexion. He's a black man of light or dark complexion. Is that what it is?
6'1", dark complexion, dreadlock hairstyle.
Okay, again. And the dreadlocks, he's wearing a hat, right? At least the video we're seeing, right? So the hat seems to be the only distinctive thing, and I just don't have a sense of evaluating it well. I mean, if it's a Yankees hat, it's meaningless, right? So this is because this hat is distinctive, because it's a Brooklyn Nets hat. What's distinctive about it? Just help me out a little bit.
The description of the hat itself, that it's a Brooklyn Nets hat, the colors, the logo, the checkered sticker, reflective sticker on the brim. So
Is it like you can go to the lid store and buy this hat anywhere, or is there something special about this hat?
I presume you could buy it at a lid store, but I don't know.
Well, I guess, and I'm not, without O'Donnell, right, you've got the hat, you've got the hairstyle, the complexion, and you've got the location.
Correct, sir.
Okay. So, but weighing against that, though, you've got the elapse of time. Everything's not necessarily specific. One of the things that I would love is, how do you distinguish this from like the DePina line of cases?
Well, so I think we're talking about Cheek, DePina, Warren, the generalized description.
Yeah.
So in Cheek, it was just a 3/4 length black jacket. There's nothing distinctive about that other than that there's nothing distinctive about that in the wintertime. Here, it's not just that it's a hat. It is a particular team hat. It is a particular logo. It is a particular style of that team hat. So it's not a 1 in a million hat, but what we're talking about here is reasonable suspicion, which just means specific and articulable facts. So it's not just the hat. It's the hat on the person wearing it that also has the hairstyle, the complexion, the size, the gender, and the location that we're talking about, basically the same parking lot where this crime occurred. And it is 12 days, but we have the armed robbery occurring, then we have him in the same location the very next day, and then 12 days later we have him in the same location.
It's a little odd because usually location has to do with proximity to the crime, where they're,
Yes, yes, which
like Van Rader is for example, as opposed to hanging out where they just committed a crime?
Of course, Your Honor, and Ducey and the whole line of cases that have to do with geographic and temporal proximity are generally because it just occurred. But here we have a situation where he is frequently in the same location, so it contributes something to the mix. And again, this is just reasonable suspicion, not even probable cause. So I'd also point to the other factor is the nature of the offense itself. And there is a plus factor that goes on the scale in the Commonwealth's side when we're talking about a violent crime involving a firearm. Here, this was an armed robbery where a shot was fired at the victim. So that adds in as well into the reasonableness calculation of their suspicion to stop this person, to confirm or dispel their suspicion. Then you add in the flight as well.
Do we also add in the O'Donnell? How do we treat O'Donnell's? Because O'Donnell doesn't testify. That's a factor right in your favor, I take it, right? That O'Donnell says he's a match or your guy is back. How do we weigh that into this? Because she doesn't testify.
Yes, it's a factor, and yes, it could be horizontal collective knowledge because it was communicated to a person. They're working collectively to try to apprehend the suspect of this armed robbery. So under Privet, it would fit as a piece of horizontal collective knowledge, but she didn't testify, so it's not overwhelmingly strong. What we do have is the officer who responded to the area and her specific observations about, I've seen this person on 2 separate days in video. This looks like the person to me. And I can give you a list of factors as to why. And we're talking about the same area. And we're talking about an armed robbery where a shot was fired. You add all of that up into the totality, all we need to clear is reasonable suspicion, specific and articulable facts to justify the stop. That was plenty. There are no further questions?
No, I guess not.
Thank you.